More trials and tribulation as Donald Trump tries to remove the federal judge from his election conspiracy case. All that and more now on Graph's Grievances. Former President Donald Trump has pleaded not guilty to the 4 federal charges he faces in Washington in connection with his efforts to overturn President Joe Biden's 2020 election victory. The felony charges brought by special counsel Jack Smith are set to go to trial on March 4th next year. But in a new motion filed yesterday, Trump's attorneys are asking the judge overseeing his case to recuse herself, claiming that she has shown bias against the former president. U.S. District Judge Tanya Chutkan, who was appointed by former President Barack Obama and was randomly assigned to Trump's case, has earned a reputation for handing out tough sentences for January 6 defendants. And when announcing at least 2 of those prison sentences, Trump's attorneys say that Judge Chutkan, quote, suggested that Trump should be prosecuted and imprisoned. The statements in question? In October of 2022, Judge Chutkan told a January 6 defendant that the people who, quote, mobbed the Capitol showed, quote, blind loyalty to one person who, by the way, remains free to this day. And in December of 2021, Judge Chutkan told another January 6 defendant that the, quote, architects of that horrific event will likely never be charged. Trump's attorneys arguing that these statements, made before Trump was ever indicted by special counsel Jack Smith, undermine confidence that Judge Chutkan can, quote, administer justice neutrally and dispassionately, and therefore are, quote, inherently disqualifying. But are they disqualifying? And who gets to decide? By law, federal judges are supposed to disqualify themselves from any proceeding in which their, quote, impartiality might reasonably be questioned, or in which they have, quote, a personal bias or prejudice concerning a party. However, it is up to the judge to determine whether to recuse themselves. And in a unanimous 1994 Supreme Court decision, it was found that an allegation of bias meriting recusal, quote, must stem from a source outside of the official proceedings. In other words, a statement that wasn't made in court. There is no evidence Judge Chutkan made any statements about Trump outside of court. So where do we go from here? Judge Chutkan has given the government until September 14th to respond to Trump's motion calling for her recusal. But irrespective of how the government responds, if Chutkan refuses Trump's recusal request, his lawyers can appeal. I, your humble correspondent, am not a lawyer, but as a layperson, it appears that unlike the vast majority of the motions filed by Trump's lawyers in his 4 criminal cases, this one seems to at least have some merit. Judge Chutkan appears to have suggested as far back as 2021 that Trump was responsible for the attack on the U.S. Capitol and that he should be charged. But we should note that other federal judges, appointed by both Democrats and Republicans, have made similar statements during proceedings of the more than 1,100 people who have been charged in connection with the January 6th attack. And while the odds that Judge Chutkan will recuse herself from Trump's case are slim to none, you can be certain that Trump will appeal her decision and further delay his trial, which Trump plans to entirely dismiss if reelected President of the United States. Thank you for watching Graph's Grievances. Let me know what you think. Please subscribe, share, and join me tomorrow for more.